The California Supreme Court strikes down the section of Jessica's law restricting where all paroled sex offenders may live. The man who engineered the deal to stick ratepayers with the bill for San Onofre is in hot water, along with other PUC commissioners. And surprise, the city's process for getting development permits is getting easier. I'm Tom Fudge, and the KPBS Roundtable starts now. And joining me at the KPBS Roundtable today are Dana Littlefield, criminal justice reporter for UT San Diego. Welcome, Dana.
Hello.
Jeff McDonald, watchdog reporter, also for UT San Diego. Nice to have you back, Jeff.
Thank you for having me.
And last but not least, Andrew Keats, land use reporter for Voice of San Diego. Good to see you again, Andy.
How's it going, Tom?
It's going okay. Well, we're going to start with Jessica's Law. Now, Jessica's Law is named for Jessica Lunsford, a young Florida girl who was sexually molested and murdered in 2005. California passed its version of Jessica's Law in 2006, and it's still on the books. But the state Supreme Court this week struck down part of the law as unconstitutional. It was the requirement that convicted sex offenders on parole cannot live within 2,000 feet of a school, a park, or other places where children congregate. And Dana, overall, what was Jessica's Law designed to do?
Well, basically, it was designed to increase the penalties for people convicted of sex crimes. It also changed some definitions of a certain type of sex offender, specifically a sexually violent predator, which is a distinction that is different from most of the sex offenders in California. Actually, less than 1% are actually given that designation. And it also increased some of the penalties specifically for habitual sex offenders. So there were a number of changes that the law made.
Okay, right. But of course, what the court was concerned about was these residency requirements. Tell us a little bit of background about the lawsuit that came before the Supreme Court.
Well, this had to do with this 2,000-foot buffer zone that was created by Jessica's Law. And that basically meant that anyone who is a parolee, sex offender parolee who's required to register as a sex offender would not be allowed to live within 2,000 feet of a school, of a park, daycare, anything like that where children might be. This was fought specifically here in San Diego County by the Public Defender's Office.
It was a San Diego lawsuit.
Yes, it was. Yes. It was fought, though that specific part of Jessica's Law was challenged because basically the Public Defender's Office was saying that there were so many parolees who weren't able to live anywhere, and they were essentially being forced into homelessness. And
we're going to get into some of those details in just a little bit, but first, the ruling. Judge Marvin Baxter wrote the court's opinion. What was the ruling? What did the court essentially tell us?
Well, the court essentially said that that buffer zone is unconstitutional, that it does violate some of the rights that these parolees do have, however limited their rights might be. So essentially, they can't get to the various services they need, and it doesn't fulfill the overall goal that Jessica's Law had, which was to make the public safer.
Now, I think you talked to Richard Gates of the San Diego Public Defender's Office. Why did his office object to the way state authorities were applying this rule?
Well, specifically, the problem that they identified with this rule was that it was being applied in a blanket fashion. So essentially, anyone who is a sex offender parolee required to register as a sex offender would not be able to live within this safe zone, this 2,000-foot buffer zone. And what the Public Defender's Office was saying was that that's untenable. No one can find any place to live. They're being forced to live, in vans and on the streets and by riverbeds and that sort of thing. And so basically, authorities weren't able to track them, and this would be a problem. It also kept those offenders from being able to get to the services they need, mental health, drug abuse, so forth.
When you think about not being able to live within 2,000 feet of a park or a school or something like that, it's kind of hard to picture how much of the actual city that would affect, but I think they had some very interesting and, I guess, alarming figures coming out of the San Diego case.
Yes, actually, this was actually included in the court documents when the case was still being handled on the trial court level. There was documentation of, I think, 90-something% of the rental properties available in San Diego County all fell within that 2,000-foot buffer zone.
Really?
Yes.
More than 90%.
More than 90%.
And then I think someone made the point that in addition to that, I mean, even if an apartment is available to you, it doesn't mean you can afford to live there.
Absolutely, yes. So there's only a certain amount of available rental property. It's public knowledge that a sex offender is a sex offender. You can look that up online. So you've got to be able to find a place that will rent to you as well.
So my understanding is that there was also a study out of like San Francisco that said it was 100%, that there was like no rentable locations to live in the city of San Francisco. And so I wonder if there's going to be any sort of legislative fix to this, because the notion of a buffer zone in general has been upheld by courts previously. So it's not that you can't impose some sort of restriction about where people can live. It's that this was so onerous that it was untenable. So I wonder, do you expect to see anything coming out of Sacramento that would basically patch the situation and give either a smaller buffer or some sort of appeals process, something along the lines that would allow people to find a place to live?
I don't know specifically about what legislative efforts would be taken in that regard, but what I do know is that the ruling leaves room for the Department of Corrections, the State Department of Corrections and Rehabilitation, to impose a buffer zone. It just can't be done on a blanket basis. It has to be evaluated on a case-by-case basis with the individual. And so actually the State Department of Correction and Rehabilitation can actually say for a particular offender that your buffer zone is more than the 2,000 feet. It could be more restrictive than what was outlined in Jessica's law.
Well, Andy Keats made an interesting point talking about San Francisco, which is a more densely populated city than San Diego. Certainly. I mean, there's got to be no place where you can live if you're a sex offender. But lest we misunderstand, Dana, this ruling does not mean that you can't restrict where sex offender parolees live.
Absolutely right. It does not mean that there are zero restrictions. Certainly there are. It's basically the means by which this restriction was being applied, specifically in San Diego. It was being applied to everyone who is a sex offender parolee required to register, and the Public Defender's Office said that's not fair and it's not working.
So as we move forward, what happens now? Does this just mean, unless the legislature acts in some way, that every case is going to be viewed as a separate case by the judge in terms of restrictions on where you can live?
Well, it means that that the state has to now evaluate how it will apply these restrictions. Does a court have to evaluate every case? That's not my understanding of how this would work.
And finally, what did our District Attorney Bonnie Dumanis say, if anything, about this ruling? I think she's been very much in favor of Jessica's law. Yes,
for a very long time. Since it was proposed, she has been an outspoken supporter of Jessica's law. She issued a statement the other day through a spokeswoman from her office, basically saying that this was just one part of the law, that she continues to support the rest of it, and that Jessica's law has done a lot to improve public safety within the state of California.
Okay, well, thanks very much. That was Dana Littlefield with UT San Diego. Well, the California Public Utilities Commission, the PUC, needs a lawyer. The expressed need for criminal defense counsel came out of a hearing this week in which the PUC's new president said the commission itself may soon be the target of a criminal investigation. In recent months, investigators have executed search warrants for the home of former President Michael Peavy and the offices of the PUC. And Jeff, what are the general charges right now against Peavy and also against Commissioner Mike Florio?
Well, there are no charges pending. There is an investigation. We learned this week there are actually 3 investigations, 2 by the State Attorney General's office and 1 by the Federal Department of Justice. The story that broke this week regarded the hearing up in Sacramento, the Senate Oversight Committee hearing chaired by Ben Hueso, who's looking into some of the things the UT San Diego and other news agencies around the state have been reporting. And that is allegations of favoritism by regulators over the utilities they're supposed to be regulating. We've uncovered emails that show they have travel trips together, they dine together, they accommodate the utilities in proceedings before the PUC at the utilities' request. They've done that numerous times. So there's a lot of questions about how thoroughly the Commission is regulating the utilities they're charged with overseeing.
One question I have is there have been a lot of sort of private conversations between these members of the Commission and executives at utility companies like California Edison. Is that illegal? Are they not supposed to do that?
It's not illegal. There are allowances for having these so-called ex parte communications. They're not supposed to rise to the level of substantive conversations, meaning you can't talk about issues that are pending before the Commission. Some of the emails we've gotten show they've done just that, however, so that's very problematic for the commissioners. Mr. Peavy was not appointed to a third term, so he's out of the picture, but he is confronting this potential criminal case. Mr. Florio has engaged in some of the same dealings and meetings and dinners that Mr. Peavy has. He remains on the Commission, so it's a going question as to whether he'll stay on the Commission or whether he'll be forced out by the legislature.
Now, obviously, people who are who want to protect consumers are saying that this access that they're giving to execs of these big utility companies is unfair.
Well, it matters a lot, yes. The evidence we've gotten is alarming because the commissioners have so much authority. They regulate billions and tens of billions of dollars a year in revenue that ratepayers pay their utility company. So they have a lot of influence over what's allowed, and that's why the position matters so much. And if they're having these secret conversations that lead to deals that are favorable to the utilities, it's only good for the utilities and the stockholders and maybe not so good for the consumers.
Yeah, I mean, there was one line in one of the emails you uncovered that was, the word choice was really interesting to me, where I think it was Florio said specifically, I'm just trying to go over the way you've trained me, or the training that you've provided. It's like he couldn't have chosen a worse word if his goal was to make you queasy about what sort of relationship was going on.
I of course thought so too, and that's why I put
that nice and high,
story.
Right? Yeah.
And the follow-up quote was, "I don't see a problem with ex parte because we're only going over the numbers here,"
yeah.
Which is totally not allowed. So, like I say, it remains to be seen what will happen. Those sorts of conversations on their face just don't pass the smell test. And it's problematic, as I say, because ratepayers get stuck with the bill.
Well, there's the smell test, and then there are actual situations where they had to make decisions about whether they would favor the utilities or consumers. One was the explosion of a gas line in San Bruno in 2010. Was Peavy, for instance, involved in that, and do you think that his involvement had any effect on their decision?
I would never say he was involved with the gas line explosion. It was a terrible tragedy.
Well, he didn't cause a gas line explosion. I mean, in terms of the way they responded. What
consumer advocates would say is that Peavy's familiarity and friendliness with the utilities led to a condition in which the utilities didn't properly maintain or keep control over their equipment, including gas lines. And it's problematic in San Bruno's case because a whole neighborhood exploded and 8 people lost their lives. It's problematic in San Onofre because their decisions led to the failure of the power plant, and we're all being asked to pay billions of dollars for the cost of a plant that's not producing electricity. So the allegation is this familiarity that Mr. Peavy, who's a former executive at Edison, that his friendliness with these companies has led to a culture where these sorts of decisions are routinely made in favor of the utilities.
Well, let's talk about the case that really does affect San Diego. Let's talk about their decision to charge ratepayers for most of the cost of the shutdown of the San Onofre power plant. What did Peavy have to do with that, if anything?
Well, we learned last month or in late January that Mr. Peavy attended a meeting in Warsaw, Poland as part of a study group paid for by a nonprofit, and that one of the Edison executives was at that meeting, and during that meeting they wrote some notes sketching out a framework for a settlement of the San Onofre costs. Now that's very significant to the investigators. It was included on a search warrant affidavit that was returned in late January, and I got a copy of it in, I think, the last day of January, and we reported on it. And what that did is it linked the PG&E corruption case that's unfolding in San Francisco with the alleged commission corruption in San Diego County and San Onofre, meaning it wasn't just limited to the San Bruno case.
And consumer advocates are very concerned about that decision having to do with San Onofre and how much ratepayers have to pay. They think that ratepayers are paying too much, and I guess that's why they would be concerned about these kinds of communications.
Yeah, California already has some of the highest utility rates in the country. This multi-billion-dollar settlement is adding to that, and this is for a plant that's not producing any electricity and hasn't for 3 years. So.
By the way, Jeff, who is investigating the PUC and Michael Peavy?
The State Attorney General's office. Okay. I knew of one investigation prior to this week. During a hearing this week, the new PUC president acknowledged there were 2 investigations underway by the State Attorney General's office. The U.S. Department of Justice also is investigating. Now, it's not clear how well they're cooperating, because the state AG's office was late coming to the investigation, the criminal side of the investigation. The feds have been at it for more than a year now.
Well, Dana, do you have any questions about this? We haven't heard from you.
Not at this time, no.
Okay. You know, Jeff, in addition to the criminal investigation that's going on, I know that Micah Geary has filed a suit against the commission over the San Onofre shutdown. How does that fit into what else is going on?
That's a federal lawsuit he filed, I think, in November, right after the commission ratified this settlement, which was negotiated in secret, by the way. Then the utility and one consumer group came up with this multi-billion-dollar settlement and then sent it out to the community, and it was approved. Mr. Geary filed a lawsuit in November challenging that. Interestingly, the defendants in the suit are not just the PUC, but also Edison as a co-defendant. So that's kind of a long-shot lawsuit. We'll see if that prevails. He's also availed himself of this internal remedy called a rehearing request, where the commission is asked to reconsider its November decision approving the settlement. It's not clear that the commissioners would approve something, approve a request to rehear something they just approved a few months ago. So we'll see what happens. If there's a criminal complaint at some point, maybe that would affect the political dynamic that is underway. But right now, we're on the hook for about $3.5 billion through 2022 for the plant that hasn't produced electricity since 2012.
Yes, we are. Jeff, who appoints commissioners?
These are gubernatorial appointments. So Jerry Brown has appointed the majority. I think all of the current appointees are from Jerry Brown. Mr. Peavy was the last holdover.
Okay, and so what's next here? I guess we're waiting to find out what is going to be the result of the criminal investigation.
We are waiting to see what the results of the criminal investigation. It's very complicated stuff. They're reluctant to talk about their progress. It's likely going to be months before any decision is made on charges. They have to reach a very high bar to, convince a jury of 12 people that they committed a crime.
Okay, well, thanks very much. And Jeff is a reporter, watchdog reporter for UT San Diego. People in the construction business like to complain about government red tape, but there's been very little information from the city of San Diego on what it takes to get a permit to actually build something, whether it's adding a room or a deck to your house or constructing a block of condos. We really had no idea how long the process took until now. Andrew Keats of Voice of San Diego has boldly gone where few reporters have dared to go into the city's permitting process. And Andy, we're here to explore this distant galaxy with you. Why did you want to do that?
Well, I mean, this is a major function of any local government, and it's certainly a major function of San Diego's. And it was one that was, it was called out specifically by a city audit in 2012 as a major risk of fraud because it was so opaque and there was such little information about it, and specifically that the only people who were aware what was going on within the system that tracks all permits within the city were people in the city's permitting system, Development Services Department. So that was one thing. And then also just when you cover any sort of land use or development or any of these sorts of issues, you hear two things all the time. One is from the development community that is saying that the city is this bureaucratic nightmare. It's Kafkaesque in its inability to give you any firm answers. And then at the same time, you're hearing from the community that is always saying the city does nothing but bend over backwards for the developers, and they approve everything that they would ever want. They're bought and paid for. And of course, these two ideas are in complete conflict, and they can't be true simultaneously. And yet, doing any sort of basic fact checking on any specific issue about what was going on writ large was impossible because the information wasn't public. And so whenever I would come forward and just say, well, what is the average time to get this permit or that permit, people would say, we can't really tell you that. No one knows that information, or the specifics are, everything is so particular to each specific instance that it's not useful to talk about things in the whole. And so it just took a long time of badgering and saying, this is public information, you need to put it forward. And they also said that the system couldn't export all of the data. It was an old system that wasn't capable of exporting the data. So when our first public records request to get it, they said, we can give that to you. It would cost $5,000 to get that information, because we'd have to rewrite new programming language to export all that information.
Okay, you got the records at a lower cost, not $5,000?
Free. We got them at free.
Okay, excellent.
Which is it was ultimately what happened, and this is I think you could say is a success of the city's open data push, was that we prevailed upon the mayor's office and city staffers that this would be a good opportunity to demonstrate what open data is capable of, so they just put all the information online at their own cost.
Okay, so you got the data. What did you find? I mean, what were some of the general conclusions you were able to come to? Yeah,
so we started basically said, okay, how long does it take? And started separating things into relevant categories of this and that. And it basically found that for the most complicated permits, the permits that, not getting your deck permit, that can happen pretty quickly. But for building a block of apartments or something, you're looking at a median time to approval right now of about 9 months. In recent years, it's been well over a year, and for certain different permit types, you're looking at well over a year still. And there are permits in the system, outliers, that are 10 years, that it takes 10 years to get your permit approved, or permits that have been active for 10 years that still aren't approved.
Now, one of your articles on permits listed discretionary review as a process that can take many months. You want to talk about that and tell us what kind of projects come under discretionary review?
Yeah, so I mean, to speak in a broad generalization, you could kind of describe everything as either ministerial or by right, which is basically you have every right to do this project. You just need to prove to the city that you're following relevant safety codes. It's not going to collapse on anybody, but you don't need their permission to do it. You just need to show that you're following the law. You get those permits quickly.
And quickly is a month?
Some of them on the day you turn them in. Others, maybe 30 days, something like that. But nothing that anyone could really say is going to increase the cost of doing business. It's a couple weeks. And then you've got discretionary permits. These are things that either what you're trying to do is expressly against adopted restrictions and regulations. So, hey, we've zoned this property that you could build a single-family house here, and somebody says, well, I don't want to build a single-family house, I want to build 10 apartments. You need to go through a discretionary process to do that. So that requires environmental review. It requires kind of a back and forth between you and the city planners about this or that or the other thing. You have to have public hearings. So that is when things get really long.
Now, the kind of development projects we cover in the media are things like One Paseo, which was recently approved by the City Council in Carmel Valley.
6 years.
6 years for that one, and that had to go before the local planning commission, the local planning group, before the planning commission, the city council.
Right.
That takes a long time.
Yeah, and most of that time comes down to, I mean, the two things that really eat up the time are the public testimony, public hearings, and of course when there's opposition, then you need to hash things out, and that takes time. But then the other thing is just environmental review. The process of figuring out all of the environmental effects of a project are timely. They themselves require 45-day periods of public review and that sort of thing. Any type of change you make restarts the clock. So, the more complicated, the longer things get. But we were able to find that over the last 10 years, which is the period that we have data for, things are getting faster. They've been getting faster every year since 2008, and they're the fastest they've ever been right now.
And why is that? Is more staff? I mean, what's going on?
Well, so the mayor's office would love to tell you, see, we promised to cut red tape and streamline regulations, and evidence here that we've done it. Unfortunately for them, there's no, they just took office about a year ago. We don't have any evidence that that's happened. There have been some streamlining and regulation changing that has taken place over the last few years. That maybe accounts for some of it. But the thing that counts for most of it is actually developer behavior on their own. It's interesting. Things got at their longest. Things became very, very time-consuming in 2008. And they were also very long in 2007 and 2009. And what we were able to find was that that was basically because people had conceived of these projects when times were good, when the real estate market was going well. They brought their projects forward, and then the economy collapsed, and they weren't really in that big of a hurry to start selling condos.
Okay, all right. Well, that's Andy Keats with Voice of San Diego, and that wraps up another week of stories at the KPBS Roundtable. Thanks to you, Dana Littlefield of UT San Diego.
Thank you.
Jeff McDonald of UT San Diego.
Thank you.
And Andy Keats of Voice of San Diego. Thanks for joining me. A reminder, all of the stories we discussed today are available on our website, kpbs.org. I'm Tom Fudge, and thanks for joining us today on the Roundtable.